This is a production of O'Brien Communications.
Hi, I'm Tim O'Brien, and this is the Shaping Opinion podcast. Our guest today is Timothy Sandefur. He's the Vice President for Legal Affairs at the Goldwater Institute's Scharf-Norton Center for Constitutional Litigation. What I wanted to talk to Tim about today was something that interests me on two levels: freedom of speech and employers' rights. And the question is, do employers have the right to free speech? And if so, how far does it go? Tim, welcome to the podcast.
Thank you so much.
It's good to have you here. This is a topic that we're going to talk about today that interests me a great deal, but I wanted to ask you a question because we're going to talk about the First Amendment.
Yes.
And you're a lawyer. So I wanted to ask you what you see as people getting most often wrong about the First Amendment.
Often wrong. Well, probably the most common mistake is people thinking that speech isn't protected by the First Amendment when it is. Public polls show, for example, that a large number of Americans think that so-called hate speech is not protected by the First Amendment when it absolutely is. And unfortunately, there's a tendency, I think, among the general public to think that speech that they disapprove of or that they don't like is somehow not constitutionally protected, when, of course, it's exactly the opposite of that. It's the speech that we don't like that most needs legal and constitutional protection. Because, of course, if you don't like somebody else's speech, they probably don't like your speech. And if we use that as an excuse to censor people, then we will all be silenced eventually by somebody else.
That's so true. It's one of the things that I heard a journalist say not too long ago was free speech is a policy in China. Because if you say whatever the government wants, the CCP, as long as you say whatever they want, you can say whatever you want.
Right. Or there's also another, it reminds me of a joke that Ronald Reagan used to say. He used to say that the Soviet Union, the Soviet Constitution protects freedom of speech. The American Constitution protects freedom after speech.
Yeah. And that's ironically too true. And yeah, there's so many examples now that we've seen in the United States over the last few years. And I can talk about this, but I'm surprised even at people who live on the basis of free speech, people in the press, people who make a living online, who through their speech in some way or another, and they themselves don't fully appreciate this First Amendment right that they have and how fragile it can be.
And, you know, on that note, there's another common misconception, which is kind of the reverse of that, which is a lot of people think freedom of speech guarantees their rights not to be criticized by other people or not to be, I hate to use this term, but discriminated against based on their speech by private industries. And the First Amendment only protects you against the government. It does not provide you with any kind of rights against private entities. And that's as it should be, because you otherwise you wouldn't have any freedom to disagree. So if I own, the common examples recently have been cases like bake shops that are baking wedding cakes and things like that. I have the right not to bake a wedding cake that has a message on it that I disagree with, because otherwise I wouldn't be allowed to disagree. And then people could use their so-called free speech rights to censor other people. So that's why the First Amendment only applies when the government is trying to restrict people's freedom of expression.
Yeah, and you just reminded me. You talk about the word hate. Certain words are so overused nowadays that that people, I think the word is offend, or being offensive. That if someone is offended, they will use whatever that perceived offense is. They'll categorize that as hate speech. And even though you just said hate speech is legal according to the Supreme Court, you may not like it. It may be truly hateful, but it is protected speech, and people take it all the way down to just you're not allowed to offend me.
Yeah,
and we've seen that. I think we're going to maybe get into some of those areas, but what prompted me to get in touch with you, and I really find this an interesting area because it's very misunderstood, and it's basically what you can and can't say at the workplace, and more particularly what the employer can and cannot say in the workplace about certain things. Now, we know that the workplace is regulated. There are all sorts of regulatory bodies that govern companies. If it's a publicly traded company, you have the Security Exchange Commission. If you're dealing with workplace safety, you have OSHA. And if you're dealing with workplace practices, you have the National Labor Relations Board, the NLRB. And I wanted to start right there. If you could tell us a little bit about what the NLRB does.
Well, the NLRB is an administrative agency, which is a fancy way of saying bureaucracy, that was created in the 1930s to regulate the relationships between employers and employees. And particularly, this was at a time when the government was wanting to encourage unionization. And so the National Labor Relations Board exists in part to preserve the legal rights of employees to organize and form unions, and not to be penalized by employers when they do that, and that sort of thing. So it's basically an administrative agency that oversees how employment works throughout the United States.
Now, the NLRB is made up, it is truly a board. It's not an elected board, it's an appointed board, isn't it? Now, how many people are on the board and how are they appointed?
You know, I actually don't know the answer to how many people are on the board, but to be appointed to any administrative agency, there is two levels. There is the senior officials who are appointed by the president and confirmed by the Senate. And then below that are the large number of employees that work for any agency, and they're hired into the civil service just like any other employment area. So it's a political appointment system. And then, like any other federal regulatory agency, and like most state regulatory agencies, they do things that combine the legislative, executive, and judicial powers in ways that I find constitutionally troubling, frankly. And that is that they write rules, investigate alleged infractions of the rules, and then penalize people for violating the rules. And of course, that is a problem, because the founding fathers rightly recognized that separating those powers was crucial to protecting individual freedom. So a lot of the time you find these problems where the NLRB will issue a rule and then come along and say, well, what you're doing is an unfair labor practice. That's what they're statutorily charged with enforcing, is rules against unfair labor practices. And they have a wide range to define that term, to say what is an unfair labor practice. And then you have to go to court to challenge those restrictions if you think that is not, an appropriate interpretation of that statutory term.
And when you go to court, do you go to a regular court, or do you take it before a sort of a court body within the NLRB?
Unfortunately, these administrative agencies usually, and this includes the NLRB, have this power to bring charges in their own in-house proceedings. So these mimic a trial, except that they're not in front of a judge, and they're not subject to the same rules of evidence and procedure that apply to an actual courtroom. And so you have to go through this administrative proceeding, and at the end of that, then you can appeal to a real court at the end. But by that time, a lot of the time, that is such a time-consuming and expensive process for a lot of people that can also be a real burden to the administration of justice.
I have one other question to establish who the NLRB is, and that is, once a person is appointed by a president, they have a term, so many years. Can the next president fire them or get rid of them before their term ends, or is there always some overlap between one presidency and another?
Well, that's a question that the U.S. Supreme Court is going to be deciding pretty soon. The answer is that for nearly 100 years now, these agencies like the NLRB have been semi-independent or quasi-independent agencies. And what that means is that the Congress creates the rules for who serves on there and restricts the ability to remove officials from a lot of these agencies. And during the New Deal, this was challenged as unconstitutional when Franklin Roosevelt tried to remove some members from one of these regulatory agencies. It wasn't the NLRB because it didn't exist at the time, but a similar agency, and to substitute his own appointees. And the U.S. Supreme Court said, no, you can't do that, and created what is, to a lot of people, constitutionally problematic, which is agencies within the executive branch that aren't really answerable directly to the president. And that's a case called Humphrey's Executor is the name of that Supreme Court decision. And most U.S. Supreme Court watchers are expecting the U.S. Supreme Court to overrule the Humphrey's Executor case, possibly in the coming year, which would be a major deal. But it would be a big change in how administrative agencies operate. But at present, Humphrey's Executor is still the law of the land. And so that means that Congress can create these agencies and limit the president's power to remove or replace the officials who are on those agencies.
The bureaucracy is really a monster that can take on a life of its own, isn't it?
It really can be. And, I, as a believer in the maximizing individual liberty, find that problematic from a libertarian perspective. But even those who are not libertarians, even if you're a progressive, this should still bother you because it is highly undemocratic. We're talking about unelected officials who can't be removed by a vote of the people, or even in many cases by the president of the United States, who are writing the rules that really govern most of how we live our daily lives. I mean, most of the rules that restrict us today are not statutes that are passed through Congress and signed by the president. They are regulations that are adopted by these administrative agencies over which the people, the voters, really have no meaningful control. So even from just a democratic perspective, that should be really troubling to you.
It's kind of ironic because this is a board that governs workplace policies and practices, yet it's established in such a way that it itself is immune. Its people are immune to the same sort of fair labor practices that would govern anybody else, right?
Well, it's not surprising. Congress, check out how many statutes Congress passes where it exempts itself from the laws. Everything from how sexual harassment laws work to minimum wage laws. Congress always is adding provisions that eliminate that excuse it from having to follow the laws that it imposes on the rest of us. If I could wave a magic wand and amend the U.S. Constitution, I think that would be one of the first things I would do, is prohibit Congress from exempting itself from the laws that the rest of us have to follow.
That's for sure. Well, we have the NLRB. We know who they are. They're based in Washington. They govern anybody who works anywhere. It doesn't even, you could work for a company, you could work for a nonprofit, you could work for the government. And if you're, a low-level employee, workplace rules and policies and regulations from the NLRB will filter down to you for sure. So if you employ people, if you're a small business person and you own a pizza shop, or if you own a major corporation, you will have to answer at some point to the NLRB if you do something wrong, especially. But even if you do something right, or you have to know what you can and cannot do. So we're now at that intersection that we love to talk about on this podcast, and that is free speech and the First Amendment. And the intersection is there and with employers. And so you have these, I would say there's three different parties in an employer-employee relationship. There's the employee, and then there's a manager who's a human being, and then there's the organization that employs the employee. That's at least three. There may be more if you have a union involved and others. But I wanted to ask you about that, because right now, and I know we're talking about a changing environment, but right now, what rights do employees have? Let's start there. What rights do employees have in the workplace as far as speech is concerned?
Well, employees, I guess I would quibble a little bit with the question, because employees, to some degree, with respect to the employer, they're sacrificing, or rather selling, their free speech rights to the employer in some respects. So the employer can limit the speech that they engage in on the business's dime in order to ensure that business can do what it does. I mean, obviously, you have to restrict or limit or instruct an employee on what they are allowed to say. If it's a flight attendant, they need to deliver the instructions correctly, and if they're customer service, they need to not say things that might be offensive and that sort of thing. With regard to the government, though, and with regard to administrative agencies, and this is, I think, what you're leading up to, is the right to organize into a union. The government prohibits the employer from restricting the ability of employees to engage in freedom of speech in conversations and communications toward establishing a labor union or operating that union. And so in some cases, that can infringe on the employer's freedom of speech rights. The employer might want to express an opinion or a view, and the NLRB will restrict that because they will say that that's interfering with the employees attempting to speak. And so, in fact, you started by saying that there's three parties to every employment contract. Well, there's also the government is basically a party to every employment contract, right?
Sure is. Whenever we get our checks, if we work for somebody else and we see the government took its share out before we saw any of ours, so they're a part of this relationship. Yes, the NLRB definitely it gets into workplace communication. Unionization is a huge part of that you mentioned. I had myself worked on a number of I would call them campaigns. They weren't our campaigns. I worked for organizations when unions campaigned to unionize, and or even in other cases where there were already unions and you had a contract coming up for negotiation and the union was waging a campaign. One thing I've always had to remind people when it comes to unions is a company may exist to sell computers, or it may exist to make the brakes for trains, anything, widgets. But a union is a communications organization that exists to communicate. It doesn't exist to do anything else than to do things on behalf of its members by charter and to its members, to communicate to its members. They're very skilled at that, but that's their mission. Their mission is, so while you have these organizations that spend so much time and energy fine-tuning, how to make those computers or how to make those products, dealing with employees is only part of that equation, whereas the union does that full time. I always thought they had to have an advantage in that sense because they're very good at what they do. But when you talk about talking to employees, it's a very, I don't want to call it a democratic process because it isn't quite that way, but it sort of mimics that, because if you have a non-union, we've seen this a lot with Starbucks lately, if you have a non-union workplace, right, and it's very local, so you have 20 people working at a Starbucks, and I'm using them as an example. The NLRB looks at those 20 people as part of a singular entity. And they don't just necessarily look at every employee at every Starbucks across the country and lump them all in the same boat. But if the union wants to organize that Starbucks, they do a political campaign in a sense. They campaign to win the hearts and minds of those 20 employees, to get them to want to join the union, to want to pay those union dues, and possibly even to want to let the union take them out on strike if at different points in the period of their employment with that organization. Now, if I'm Starbucks or any coffee shop that a union wants to organize my people, that is where we get into the speech issue. Because it seems to me, and I'm looking at this from the standpoint of a not a lawyer, of a communications person. It seems to me that the unions are able to sort of wage that campaign with both arms untied from behind their back, and it seems to me that any employer that has at least one of their arms tied behind their back, there's a lot of things they can't do for fear of being not only accused, but found to have committed an unfair labor practice. How does that dynamic work?
Yeah, no, you're absolutely right. That, and now I would take a step back and say a union is a cartel, and I don't mean that in a offensive way. I mean that in a literal, technical, economic sense. That a union is a cartel of labor. It is an attempt to drive up the price of labor by finding ways of limiting its supply. And the way you limit the supply of labor is by restricting competition. And one way to restrict competition is to prevent the employer from choosing to hire anybody else. And so you find a lot of the time what unions are engaged in is restricting employer choices, the ability of the employer to hire somebody else, or restricting employee choices, restricting the ability of workers to accept jobs that they would like to accept, because to do so would drive the general price of labor below what the union wants. So the union can say, well, from now on, the price of labor will be $100 an hour. Well, the employer is going to be like, well, I'm not nuts to that. I'm going to go hire somebody else for $50 an hour. The union is going to try and restrict the employer from doing that and find ways to prohibit anybody from taking that job in order to prevent competition in the price of labor. And speech is one of those things. The union will try to limit the ability of employees to speak their minds or express their opinions in various ways. One of the most obvious examples of this is restrictions on the ability of workers to leave the union. We have found case after case in just the past couple of years where what unions are doing is they create a rule that says you're only allowed to resign from the union during a 2-week period in the middle of December or something like that. And you're not allowed to leave the union otherwise. Or in order to leave the union, you have to hand deliver 50 signed copies to the president of the union personally between the hours of 5 and 7 p.m. And these kinds of really arcane and difficult to follow rules in order to make it as hard as possible to leave a union, because the union gains its strength by restricting the ability of employees to accept jobs that they otherwise would accept. Now, maybe that's fine. Maybe that's a good idea. But the real problem arises when you are restricting a constitutional right. And when you're restricting the ability to make a contract, limiting the employers from making choices or employees from making their choices or from speaking their minds, that's a real problem. And of course, that mostly comes about with government unions. I mentioned that the First Amendment only protects you against government's actions. Well, a government labor union, a public employees union, will often restrict the ability of public employees to speak their minds, to either quit the union or to refuse to subsidize the union out of their paycheck. And that's what gave rise to the big Janus versus Afshmi decision. What was that, 5 years ago or so now, where the U.S. Supreme Court said that public employees have a constitutional right to choose not only not to join the union if they don't want to, but to choose not to fund the union if they don't want to. And that's a great win for employees' rights. But of course, the labor unions spun it as a terrible assault on workers, because the labor union leadership gets its power from these kinds of restrictions. And so it wants to try and pretend that those restrictions are good for employees in some way. I know that I've kind of strayed from the question you asked, but these constitutional free speech issues arise in a wide variety of contexts, and they limit not just the rights of employers, but also the rights of employees.
One of the things you said reminded me recently, you talked about the rights that the unions have and what they try to achieve. And you talked about how they try to make it harder for companies to hire non-union people. But that's assuming they hire non-union people. We saw last year with the longshoremen's stalemate and then strike that the big issue for the longshoremen wasn't other people, or as they call them, scabs, non-union people. The big problem for them was automation.
Yeah.
Because they were worried and are worried. And I think it's more, if you have to simplify it, get the money while they can, because they got this gigantic contract and everybody agreed to it at that point. But they more or less just bought themselves some more time, because I think what they see coming is a lot of these longshoremen members of that union, they're going to be replaced by these automated arms and robots on the loading docks of these shipping facilities, because even though that's pretty expensive technology, it's not as expensive and it can be, it doesn't have sick time and you don't have to worry about health benefits for a robot. So it can be perceived by employers in that area as more cost effective. So my point of that whole thing is that unions now have new competition, and it's called automation, and it's a whole new dynamic for them. And
in the past, you've seen unions deal with that both through, you might say, Luddism, that is being completely opposed to new equipment or new technology, but also what is known as feather bedding. Feather bedding is a process where the union requires the employer to hire unnecessary employees within the collective bargaining agreement. So, and the classic example is that for a long time, unions required railroad companies to hire firemen, that is, people who feed the boiler on a steam engine, required to hire a fireman for a diesel locomotive for many years. Totally crazy. And that is now illegal. But unions still find ways of engaging in feather bedding, or in what I like to call reverse feather bedding, which is they will often get laws passed that prohibit employers from terminating employees unless the employee is in a union. And these were passed in California several years ago regarding grocery stores. And so what the law says is if one company buys another company's grocery stores, Ralph's buys Save-On or whatever, then the new company is not allowed to terminate any of the employees unless they're members of the union. And what that does is it makes it more expensive for a company to have non-union labor. And that's the number one goal of the union, is to make it as expensive as possible for employers to hire non-union labor so that the union can raise its prices. And, there are other ways. We've been talking about kind of these unfair and illegal ways of adopting that. But there are other ways that unions will accomplish this. And a lot of it is also speech, propaganda. And again, I don't mean that in a pejorative sense. I mean that in a technical legal sense. That propaganda is designed to encourage people to only buy union-made product and to tell people that there's something wrong about hiring a non-union labor or something immoral or dirty about it. And, back in the 70s, you used to see lots of commercials. I only buy the union label and that sort of thing. This propaganda is designed to encourage consumers to spend more than they otherwise would so that the union can ensure higher wages, above market wages for its members. And again, that's perfectly fine, except when you're engaging in coercion. When the union is, or the government is interfering and restricting the free speech rights or the freedom of choice of workers and employers, then that's immoral, and I think it should be illegal.
When you talk about coercion, and again, we'll go back to this. I want to get into more detail about the process, but anytime the union has a local vote, whether it's to ratify a new contract or to unionize, when they get to the point of a vote, oftentimes you have an option. You have a secret ballot, or you have more or less a show of hands. And most people in a democracy say, well, what do you mean a show of hands? I mean, democracy is a secret ballot, right? I mean, when I go to vote for president or the governor, I have a private little booth because my vote is sacred and private. But when you're a member of a union, in some cases, and it sometimes is decided at that local level, it's decided then we're going to have a show of hands. So you introduce the concept of peer pressure.
That's right.
Or coercion, or worse, later on, because they know where you live. And
I'm proud to say that we, in Arizona, this was going back 20 years now, the state adopted a law requiring secret ballots for union elections, and we at the Goldwater Institute championed that and successfully defended the legality of that requirement in the Arizona courts. Because, as you said, we have to prevent the peer pressure from being used as an unfair tactic by unions to cement their power over workers who have a right to decide for themselves how they're going to earn a living.
They do, yeah. That's okay. So I think that sets the stage for some recent developments. And I'm going to refer to something that I read here, and this is where I need you to walk us through this, because there was a court ruling recently that employers, the court ruled that employers have no standing to sue over federal administrative guidance that block them from expressing their views about unionization. Now, I'll translate what I just said, and then I'll ask you about this. Basically, what this is about is if unions want to organize and senior management at the organization have an opinion on whether unionization is good for the company or not, they can speak their minds. And that way the employee can hear both sides of the argument, you hope, ideally. And a case in point, just an example of why, and this is something that if I'm an employee, I want to hear. If you can tell me that unionization will raise the cost of operating for my organization so much that we will become less competitive and we eventually could go out of business, I want to know that. And because I don't want to vote for my own demise. I don't want to vote for my organization's own demise. And again, I'll go back to this. I've seen this. I've worked on labor contracts where you've had unions out there out front, and the company said in a union negotiation for an existing contract, they had said, look, we can't afford this anymore. If we don't either hold things as they are or get concessions, we're going to go out of business. And I can still picture, I'm in the Pittsburgh area, I can still picture this one time where the picketers were outside the plant as the trucks were taking away all the heavy equipment to another plant because they were shutting that plant down. And the local news went to them and said, "What do you think?" And these union members said, "They're bluffing." And I'm thinking, it's so sad because they were convinced by somebody that the company was bluffing when it was literally physically taking these carbines out and taking them to another plant where they would be used. And it was sad. And I hate to see that. And I've always felt that way when I do my own labor work with organizations, is I want to do right by the people that are affected by this. And it can be a real game that they're pawns in.
Absolutely. Yeah, wise union leadership will know that you've got to be careful not to kill the golden goose. And unfortunately, there's an incentive for labor union leaders to be as aggressive as possible sometimes, and by being aggressive to make such heavy demands on management that eventually the business is driven out, and then nobody has a job. And unfortunately, I think we've seen that in a lot of America's industrial sector over the past century. I actually have a political cartoon from the 1870s framed on my wall in my office that shows a butcher standing over the body of a dead goose, and standing next to him is a labor leader and he's going, "That's funny. There's nothing inside it after all. I was sure he was just full of golden eggs." And so it's a problem that has gone on for as long as organized labor has existed. Again, although obviously I have a much more free market orientation than a lot of people, I don't mean all of this to come off as sounding that I'm in principle saying labor unions are terrible in principle and all that. No, labor unions serve an important service in the economy, a very important service. It, aside from all the things that we've been talking about, they help out employees, workers who need help in various ways. The insurance policies, organization for community stuff, all sorts of good things. But it does happen sometimes that labor will make demands and, as you said, be so short-sighted that even when they're trucking the jobs away, the union is still acting as if it's being mistreated in some fashion.
Yeah, to your point, when my kids were little, we sent them to a small Catholic school, and it got into the Catholic school just wasn't prospering, so we ended up deciding to send them to public school. One of the things I liked about the public school that we lived in, the neighborhood where we lived, was that it did have a teachers union. And the reason I liked that from that point of view, from the point of view of the parents, is I liked the idea that the teachers were protected by the union from the parents, because you couldn't necessarily have a parent walk in because they were the biggest donors to the school. And their kids were exempt from all the rules, and they could do anything they want or whatever. You had a little bit more of a level playing field for the students and the teachers because of that union. That same union had issues then when it came to contract time, where I disagreed with the union, but you get both. And I thought our kids benefited from that existence of that union in that way. Now, this case. What can employers say? And aside from the issue of standing, what can employers say and what can they not say if employees in their Starbucks store want to or considering joining a union?
Well, this case began when the Department of Labor issued a guidance memo limiting how employers can speak to employees under these circumstances. Now, I should start with explaining what a guidance memo is. So these departments, these bureaucracies, they can issue regulations, and these regulations are basically just laws, right? They're rules for how things operate. But in order to pass a regulation, there's a process set out through the Administrative Procedures Act, which is a federal law passed in the 40s, that says before an agency can write a regulation, it has to announce that it's thinking about writing a regulation, and it has to open it up for the public to make comments about it and say whether it's a good idea or not. And there's a whole procedural, thing that it takes a while to jump through all these hoops and all that sort of thing. So sometimes what an agency will do is it doesn't want to spend that time, and maybe it's already made its mind up and it doesn't want to hear what other people have to say or whatever. And so they'll issue something other than a regulation. We sometimes call it sub-regulatory rules, or I've heard it called regulatory dark matter. And the reason why is because these are not formal regulations, and so they're not published. People don't often find out about them. And one of the ways of doing that is through a guidance memo. A guidance memo is just a memorandum that says, we interpret the law in the following way. And it can be issued even by just a single bureaucrat at one of these agencies. Now, of course, everybody knows when they see this memo, they know that in reality, you better follow that rule because that really is the rule. But because it's just a memo, it hasn't gone through the process of the public comment and review and publication, all that sort of thing. And so it escapes notice a lot of the time. What happened here was that the NLRB issues this guidance memo that says, we interpret the rules as not allowing the employer to require employees to attend a meeting where the employer expresses its opinions about unionization. And in particular, an employer is not allowed to, quote, corner, end quote, an employee to discuss unionization. What does cornering mean? Well, obviously, in ordinary speech, we think of cornering as, the person backed you up against a wall and wouldn't let you leave and was like yelling at you or propagandizing to you or something like that. But of course, there's no legal definition of the word cornering, and what exactly that means is kind of vague. And so this guidance memo sort of basically just tells employers, you're not allowed to require your employees to come to a meeting where you tell them what you think about unionization. You can talk to them, but you can't require them to come to the meeting. So nobody's going to show up. So you're going to be talking to nobody. That's basically what the rule is. And of course, employers really would like to tell their employees, hey, here are the downsides, in our opinion, to unionization. Here's why it might be a bad idea for both of us, and that sort of thing. But now they're afraid to do so because they're afraid that they'll get punished if they try to do that.
So when you talk about cornering, and that's basically speaking to employees as a captive audience.
Yeah.
Can an employer put a social media post out to express those points of views and employees can find it? Or can they, and I have some experience with this, is can they put a radio commercial out or a newspaper ad out to express those points of view in hopes that the employees see that?
Yeah, that wouldn't be requiring them to attend a meeting. And I don't think whatever cornering means, it probably does not mean that.
So they would have that right.
Yeah.
Now, the employer, are there certain things they can't talk about and can talk about when they do communicate on unionization versus non-unionization?
Well, I don't know the specific answer to that question, but they typically, an employer is going to be very careful in their speech because they don't want to engage in speech that might sound threatening, for example, right? Threatening employees who are considering unionization would be considered an unfair labor practice, because what the law is interpreted as meaning is that they want to protect the ability of employees to get together to talk about, or to get together to form a union or something like that. So if the employer gets up there and says, I'll fire you all if you organize a union, that would be an unfair labor practice. And sometimes it's very hard to draw that line. Sometimes it's really hard to figure out whether what the employer is saying constitutes the kind of threat that would qualify as limiting or intimidating an employee into not speaking their mind.
And anytime you hear the word threat in this context, you also then see it coupled with the word retaliation.
Right.
Because threat would be, warning somebody that you might do something bad. And retaliation is when the employee has done something and you did something else in retaliation. So an example that the unions might use to accuse an employer would be, they retaliated against our organizing effort by firing one of the organizers.
Right.
And use that person as an example for the others. So it wasn't quite words, but it did something that chilled the whole atmosphere for that.
And it can be, it can be something short of firing too, right? A retaliation is also one of these vague terms. What exactly is retaliation? Something like, maybe the employer assigns fewer hours or reassigns the employee to another job that the employee doesn't like. Is that retaliation? Maybe there are other good reasons for the employer to do that. Maybe the employer had been considering reassigning that employee for 6 months beforehand, and it had nothing to do with it. Or maybe it was a little bit to do with it, but not really. Well, those are hard lines to draw, and especially when you have to draw them in an administrative hearing or in a courtroom long afterwards, when you're having to pay your lawyers, $500 an hour, or travel, as far as it necessary to go to the hearing or the courtroom, and it's time that's wasted and it's expensive. And so it really, you talked about a chilling effect. It creates a chilling effect for employers also. And maybe it would be worth explaining that the phrase chilling effect is something that lawyers use all the time to explain to describe the situation when somebody doesn't get punished for speech, but is afraid of being punished for speech. And so the person chooses not to speak, right? We call that self-censorship. And a chilling effect is when, the guy next to me got punished for speaking his mind, so maybe I'll keep my mouth shut, right? Well, that's just as effective a form of censorship as outright punishing me, right? So you only have to punish one person in order to censor 100 people because of this chilling effect.
And that is part of this discussion. So you have this sort of framework for what employers can and can't say, and going back to that hand tied behind the back. So a union can make baseless claims about the company. They can say they're going to move your jobs overseas, they're going to do this, they're going to hire this person, with no basis in truth. They can say things like, they'll make you work twice as long, and they'll fire you at will, which is often the case that they can do. And they'll use that again. They'll talk about benefits. They're going to raise the price of your benefits. And all of this doesn't have to be backed up by any kind of fact. The union can just sort of say it. But if the company or the employer says something, that has to be verifiable fact. They can't project the way the union can. So in other words, the company can't say the union just wants your union dues, and they can sort of indicate that, but they can't just come right out and be anti-union, or be perceived as anti-union, because that's a short jump from that to anti-unionization. So if the company can be accused of being anti-unionization, then that's an unfair labor practice, isn't that?
That's right.
So you have all these, I guess, walking on eggshells situations for the employer. And we got this situation where the NLRB threatened to punish employers who want to talk to employees about unions. And they came up with, as you said, this memorandum that now has sort of the binding law. And you had the courts come back and say, yes, the employers have no standing. Where does that case stand now?
Well, right now it's in the Fifth Circuit Court of Appeals. And what the issue about standing is kind of outside of what we've been talking about, unionization. There's just a general rule in all cases that you can't go to federal court unless you have standing. What does standing mean? Well, in theory, standing is supposed to be a rule that says you're only allowed to go to court if you really have a stake in the matter. You can't just have a general objection to something and then go off and ask a federal judge to strike down a law that you just don't like. You have to actually be injured or affected by it, or that you have to show that you are going to be injured or affected by it in the near future. So the employers in this lawsuit, they said, well, we're being chilled in our ability to express our views regarding unionization by this guidance memo. So they filed a lawsuit represented by our friends at the Texas Public Policy Foundation. And the court said, well, you haven't really proven that you want to speak, you employers. You haven't shown that you're going to speak in the near future and that you're going to be penalized for it. And so come back to us at some future date when you've either been punished for speech or when you are just about to be punished for speaking against unionization in the workplace. Now, there's a lot of problems with that. One of the problems is that, but this, as we mentioned, the chilling effect, where people are scared to speak their mind because they're afraid of incurring punishment, and so they censor themselves. Well, you can see there's sort of a paradox there. If on one hand, under the standing rules, you can't go to court unless you can show that you've been punished in some way or are just about to be punished. On the other hand, you have the chilling effect, which is where people are so scared of being punished that they don't speak in the first place. Well, then you have a paradox, because then you could never go to court to challenge a chilling effect, right? If you censor yourself, if you're afraid to speak out, well, of course you're not going to file a lawsuit. If you're scared to speak, you're not going to sue. And so you have this sort of paradox where the government, if it's good enough at scaring people, it can get away with it, right? That's what happens as a result. And so in this case, we filed a brief in the Fifth Circuit asking for all of the judges on the Fifth Circuit to reconsider this case, and to keep in mind in doing so this paradox that it cannot be the case that the employer stands up and says, I'm afraid to speak, right? If they're afraid to speak, then they're not going to do that. That can't be the rule. I should add, I mentioned that this case has been decided by the Fifth Circuit Court of Appeals. There's a step that you can take after that where you ask all of the judges in that Court of Appeals to reconsider the case. That's called en-banc rehearing. And that's the stage that this case is at right now. After that, you can also go up to the U.S. Supreme Court after you've done that. So that's where this case is right now. We've asked our friends at Texas Public Policy Foundation and Goldwater Institute have asked the court to reconsider this case in light of this silly rule. And by the way, there's another aspect to this that is also silly, which is the whole point of the employer's speech here is that they want to prevent the employees from deciding on unionization. They think that would be a bad idea for the business, and so they want to speak out before the employees have their meeting about unionization. Because if they wait, then it's an unfair labor practice for the employer to try and dissuade them once they've decided upon it. And what the employers are trying to say is they're trying to say, look, this is a bad idea. You shouldn't go down this road. Maybe they're wrong. Maybe they're right. Who knows? But they have a free speech right to express that opinion, and by expressing the opinion, to dissuade the employees from taking that step. But by saying that they don't have standing to sue, what the Fifth Circuit did was it basically said, no, you have to wait until the employees begin the process. And by that time, it'll be too late, right? So it's a funny problem. It's not just confined to the unionization area. It's across the board. You have this problem where courts don't want to hear a case until you've been injured. But at the same time, the whole idea of a chill effect is that people don't incur injury because they're afraid to speak to begin with.
Well, let's go back, and I'm going to restate what you just said, because I think it's a key point, and that is, and I'll use the scenario of unionization, though you just said it's not limited to that. So you have a group of employees that may want to join a union, but according to the court, it's too early yet. The company can't speak out against the union at that point in time. So the union, there was a vote, and the employees decide, yes, we do want to form a union, and they start to follow the processes to actually join a union. It's not a done deal yet, but the process has begun. They took a vote. They had a petition process, and then they took a vote. And now the employer can't talk because now they'll interfere with that process. Right. So they can't talk beforehand, and they can't talk afterhand. So basically they can't talk. Right. So I wanted to ask you, and I'll go back to, again, what you said. The employers are required to prove they want to speak before they're allowed to speak. And then when they're allowed to speak, there's all these other regulations that will limit what they can and cannot say. So my question for you on that, and you used the term yourself in something that you wrote, a Catch-22.
Yep.
Catch-22 is a great book by Joseph Heller that I read in high school. And the thing I like about the whole concept of Catch-22 is because it focuses really on the absurdity of government thinking. It doesn't lay out conspiracies. It just talks about these oxymorons like military intelligence, that kind of thing in that book. So that's where that term Catch-22 comes from. So my question for you here is there malicious intent, or is this just that absurd bureaucracy thinking when we have these dichotomies of what people can and can't, what employers can and cannot do?
No, it's definitely not malicious. It definitely is the absurdity that you described. And in fact, it's the problems are often worse when it's not malicious, and it usually isn't. what I mean by that is the typical bureaucrat wants to do a good job, right? The typical government employee is a conscientious, hardworking person who wants to do the best job possible for that bureaucracy. If they're in the Department of Widget Control, they want to control widgets as effectively as possible. And that means that they have to define the term widget as broadly as possible. And so there's this natural tendency of the bureaucracy to grow and to expand its power and to assert its power to the utmost in all cases. And then you have a problem not only with the fact that the Constitution inherently limits government in many ways, but you also have a problem in the fact that sometimes bureaucracies have different missions. And so you have conscientious bureaucrats butting heads over jurisdiction and the range of their authority and what the words mean and that sort of thing. So one of the roles of the Constitution and the courts is to rein in the power of the bureaucracy precisely when it is being as diligent as possible. It's when a government bureaucrat thinks that he or she is doing what is good for the country, that person is most likely to engage in unconscionable behavior because they think they're doing the right thing. And if you want to persuade somebody to do something terrible, the first way to do it is to persuade them that it's the right thing to do. And unfortunately, that happens rather frequently with bureaucracies.
That is interesting. Now, there's a process that's built into most government procedures, and you could call it sunshine laws, but it usually involves something where if somebody wants to do something, there's an open comment period beforehand. Right. And I would think that since the government does this as a matter of course, that something like that would be built into the labor relations process as well. But it seems like in certain situations, employers are not given even that period of time where they can sort of make public comment, make their case. Am I oversimplifying it, or does that not exist?
That you're right about that, and that's not just confined to the union context. That's the big problem with guidance memos and so-called regulatory dark matter. Another term for them is dear colleague letters. You might have heard a lot about this about 10 years, in the previous 10 years, the Department of Education under the Obama and Biden administrations especially was issuing these dear colleague letters. That they're called that because they start out with dear colleague, the Department of Education thinks this is a problem and so forth. Again, those can be issued by a single bureaucrat. And since they're just a letter and they don't qualify as a regulation, then they don't go through the notice and comment process. So there's no public input, no requirement for the agency to consider what the public thinks about things or weigh the costs and benefits and that sort of thing. And again, it's not just in the union context. We often see this, especially in the environmental context, with environmental agencies like the EPA that have the power. A single EPA official can issue an order declaring an area of land to be a wetland, which means that the Clean Water Act applies, which imposes all sorts of extremely expensive and burdensome restrictions on property owners. And that can be done without public input, leading to huge Supreme Court cases over what qualifies as wetland and so forth, and restricting a person's ability to use their property. So you find this throughout the bureaucracy, and it often does give rise to these kinds of catch-22s, as you said, that you haven't been injured because it's not a rule or something like that. Well, yeah, but you can't challenge it because it is a rule, so you're restricted by it, and you have to be punished before you can defend your rights, and all these sorts of weird paradoxes that you find sometimes in the law, thanks to the growth of the undemocratic administrative state.
It's almost like a person who works, like you said, for the EPA or the NLRB, as long as they work there and they have that letterhead and they can put something on that letterhead, it's almost like they have this almost autocratic power, and they have the unlimited.
Which is inherent in bureaucracy, right? Autocratic power is just how the bureaucracy works. And sometimes I do think, I'm often reminded in this context, there's an episode of The Simpsons where Bart becomes hall monitor, and he's wearing the sash and he's wearing the sunglasses, and somebody asks him, well, Bart, you used to be a rebel, and he says, yeah, and then I got my first taste of authority and I like it. So I often think of it that with regard to bureaucracies, but the reality is that most of the problems with bureaucracy are conscientious people trying to do the best they can, which they see as expanding and protecting the bureaucracy and its authority as much as possible. And of course, that infringes on individual rights.
That's so key. Well, what about the employer themselves? You said, dear colleague, that letter. And So let's suppose I own this pizza shop, and maybe it's unionization, maybe it's a different issue, but I want to communicate to my people, but I know that by law, because I'm the owner, I can't do it. But I have one of my right-hand people who is one of my employees, but that person's maybe a manager. Can I tell that manager, hey, why don't you tell these people this, that, and the other thing? Or what happens there?
No, that would probably also be an unfair labor practice. If you can't do it, the general rule in all of the law is if you can't do it, you can't ask somebody else to do it either.
So that would be a form of coercion.
Yeah. And there, now see, you use the word coercion, and it's funny because I used the word coercion earlier, and I was talking about situations where the government comes in and forces an employer to do something or prohibits an employee from doing something. And that's literal coercion, because that if you break that rule, you're going to either be fined or go to jail or something like that. You're going to be actually physically punished. But in the labor context, you often find people use the word coercion to mean something other than that. What they mean is, well, the employer, fired me or docked my pay or limited my working hours or something like that, which is not coercion at all. You're not going to be thrown in jail or beaten up or have your stuff taken from you. But this doublespeak uses the word coercion to refer to changes in circumstances, and it's just a way of manipulating the language in order to get away with a sleight of hand. And unfortunately, a lot of our law depends on that.
Well, the employer is in a position of power over all employees. They can always take away the job, so they have that power. And
that's true. Although, remember, when we talk about positions of power, the real question in any situation, because all contracts are between people who have a different position of power. I mean, if I hire a lawn guy, it's because he knows how to cut a lawn and I don't, So position of power is another vague term. So we have to remember that the real question is it efficient for both parties to a contract? And the only way to know that is if they voluntarily agree to it. If the question is, does it make the people better off? And the only way to know it makes people better off is if they agree to that contract. So that's the answer to the position of power issue, is that if people voluntarily agree to a contract, it doesn't matter what the positions of power might seem like to you and me, they agreed to it. So that means it's fair between them.
Well, let's get down to, I guess, the core issues. And that is, and I'll ask an open-ended question and tell me what you think. Do employers have a right to free speech in America?
Do they I guess I have a difficulty answering that, because the answer is, of course, they have a right to free speech, in that all of our rights are not gifts from the government. They are protected. They come from our freedom as human beings, and the Constitution respects and guarantees those rights. But the reality on the ground is that employers today have their free speech rights violated through and throughout by government regulation of the workplace. I would also add, so do employees. They have their freedom of speech violated day in, day out by government regulation of the workplace in a wide variety of ways also. The only real solution, if we want to protect free speech as well as other kinds of rights, freedom of contract, private property rights, is to limit the authority of government as much as possible. But in the labor context, that the government thoroughly saturates the labor market with all sorts of rules that violate the free speech rights, both of employers and employees.
Well, could you provide one example of how the government restricts speech of employees?
Well, one that comes to mind immediately is not in the union context, but would be in when it comes to sexual harassment law. Sexual harassment law has now metastasized and grown to such a degree that employees are terrified to speak their minds about things sometimes, or even just compliment somebody on their outfit or something like that, because you never know what can qualify as a hostile work environment. It's so highly subjective that it does restrict freedom of speech. I would refer you to, there's a great book by my friend David Bernstein called "You Can't Say That," which describes how sexual harassment law has now invaded the workplace to such a degree that it violates the free speech of employees and employers across the market.
That's and that is a complicated issue, because obviously we can't have people in a workplace making other people uncomfortable to the point where it's really a distraction. And let's say from a business point of view, it ruins productivity at the very least, but it's unethical and wrong.
Yes.
So
But unfortunately, what is defined as harassment is so vague that it can also become just whatever a person says it is, in which case it creates that chilling effect. People are afraid to speak their minds because they're afraid they'll get punished for things that really they shouldn't be.
Yeah. And then there is human nature. And this is the kind of thing I've run into in my crisis work. And, people will make allegations and say certain things because they can, but you find out their motivation was less than pure,
Oh, yes. And the fly in the ointment is very often human nature.
It really is. It's I can think of one case where you talk about hostile work environment. We had a subordinate who was baiting their supervisor to make jokes with them. They had a lot of banter in the office, and it was very harmless. Even when it ended up in court, it was harmless. When you looked at the words, they weren't. But the former employee, now the subordinate, was suing the employer based on this banter that they had between them. And we find out in the course of the trial that or the court proceeding, not the trial, that we find out in the course of that it was all planned and everything by the subordinate. They were basically just trying to set their boss up so that they could come back later and sue and get some kind of damages. And we had to try to, I was working with the organization, and we had to try to bring that to light in the right way. And the lawyers did a good job because they did bring that to light, and the court proceedings spoke for themselves. I have one more question for you on this whole issue of employers in this case, but it's not just this case. Where do you see it going from here? Where do you see, will employers in the future have more or less freedom of speech? That's the broad question. And what happens in this case in your mind?
That's a really hard question to answer. I think the current administration wants to roll back a lot of these kinds of efforts that were, these guidance memos and things that were created in the Biden and Obama administrations. But so far, we've seen little sign of reform in those respects. And changes of that sort also take time. I mean, those also often have to go through notice and comment. And so the previous Trump administration tried to roll back a lot of regulations, and then those rollbacks got declared illegal because they didn't go through the proper steps. So unfortunately, even if there is a desire to change it from the top, that can be very difficult to accomplish. So in the short term, I wouldn't be surprised to see employers getting more protections for their free speech. But I think in the long term, unless there is serious legal reform, you're not going to see that last very long. Any efforts to change things in the next 3.5 years will probably be overruled the moment another administration goes into place. Whether there is an effort, whether there's any kind of political will to make those kinds of reforms, I don't think there are. And so I think that employers can expect to see their not just their free speech rights, but their other constitutional rights further curtailed in the long term until somebody stands up for the rights of the wealth creating businesses in this country. And, we try as best we can, those of us in the free market movement, but there's a lot of work to be done.
Timothy Sandefur, thank you for joining us today.
Thank you.
The Shaping Opinion podcast is a production of O'Brien Communications, copyright O'Brien Communications 2025. Find us on Spotify, Apple, or wherever you listen to podcasts. If you like to watch, go to YouTube, Rumble, or our Substack page, shapingopinion.com.